Good morning and welcome to the Shenkman Private Client Group Accountant Attorney Fall Webinar Series. This program is entitled How to Plan for Unequal Inheritances and the Complicated Divisive Issues that Arise with Unequal Inheritances. For those who don't know me, my name is Jonathan Shenkman. I'm a financial advisor, portfolio manager, and an accredited investment fiduciary at Oppenheimer based in New York City. The goal of all my programs is to bring professionals together to help them better serve their clients. This is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between client's attorney, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not-for-profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. In addition to the 2025 events I run every year, I also do a fair amount of writing on the topics of investing and financial planning. You can read my work in Barron's, CNBC, Forbes, Kiplinger, the Wall Street Journal, the CPA Journal, Trust and Estates Magazine, and many other periodicals. After the program, I'll send out a link to all the publications where I publish my work. Today, we're privileged to hear from Avi Kestenbaum, partner at Long Island-based law firm Meltzer, Lippe. Avi co-chairs the firm's Trust and Estates practice group, where he provides creative and sophisticated domestic and international tax, estate planning, and asset preservation counsel to CEOs of major corporations, ultra high net worth individuals, multinational businesses, and large charitable organizations. He has successfully represented many clients, including trusts, estates, businesses, and charitable organizations with IRS and state tax audits. Avi has also published dozens of articles in leading tax, estate planning, and tax-exempt organization publications, and is a member of the Trust and Estates Magazine editorial and advisory board, where he's chair of the Modern Practice Committee. He's also adjunct tax professor at Hofstra University School of Law. Today, Avi will be speaking on how to plan for unequal inheritances and the complicated and divisive issues that arise with unequal inheritances. And with that introduction, I'll now turn the program over to Avi.
Thank you, Jonathan. Good morning to everyone in virtual land out there. Jonathan, I want to thank you again for the opportunity. It's amazing that you put this together. The fact that your programs and seminars are so well attended, really terrific. And I think everyone who's listening or watching, it's still relatively early in the morning. I also thank Kim Kamen, who was the author of the my co-author of the article in Trust and Estates Magazine on which this program is based. Kim and I did a similar program for Trust and Estates Magazine a few months ago, and this is a different view or a similar view of that program. Also, one of my associates, Elliot Dizon, who was a co-author of that article. So it's really nice to have a little bit of a break, at least for a half an hour, from the impending, imposing, and potential tax legislation, which we're all about to receive, and perhaps some of us are losing our minds over. It's one of the busiest times, if not the busiest time, in tax and estate planning history, where everyone is trying to figure out what to do and to act very, very quickly. So this is not tax oriented, and as I tell a lot of people, I spent the first half of my career trying to become the greatest tax expert ever. I failed, though thankfully know enough to write and teach a lot about it. But the bottom line is, what I've learned is taxes are extremely important, and I spend 90% of my day dealing with helping people save all sorts of taxes. But what's even more important are the family dynamics. And oftentimes we hear this stuff referred to as the soft topic, and it's nothing, either you can do it or you can't do it, but I don't think so. And in fact, studies indicate the greatest potential failures in estate planning is not about taxes. And when assets leave a family, whether it's a business being destroyed, whether it's children, grandchildren not having money or assets anymore, it's not about the taxes. That's a very, very small component, but the family issues and the family dynamics, that's actually the greater source of destruction, both monetarily and also in terms of the family unit, happiness, feeling good about life, children, grandchildren, family. And at the end of the day, why do we work so hard? We work so hard because we want to see our descendants have a better life. So I really don't think that these items get enough importance. I focused a lot on topics like family businesses and how to make sure that the family business succeeds down the generations. Believe it or not, there are a lot of studies on family businesses. What are the components that help the business, what don't? And I don't think there's enough studying, emphasis, and focus. And there is data out there, and it's very, very helpful to have that data. And just like Jonathan offered his materials, I do have some articles that are not included in this program regarding family businesses and how those businesses will have a greater chance of success, and the historical data of the businesses that have succeeded more than one or two generations. What are the common elements and components? So I've got about 25 minutes left, and I did want to emphasize how important this is, and again, getting a little bit of a break from the tax legislation, and let's dive right into it. So unequal inheritances, and we've got some a discussion overview, but we'll go to the next slide. So firstly, children have no automatic right to inherit under the law. A spouse does in most states. There are ways to try to prevent a spouse from inheriting, but under the general default rules, if somebody dies without documents, a spouse obviously inherits. And if there are children, the children generally inherit as well. Again, one can disinherit children. There's no laws that a child must inherit. A spouse must inherit, subject to working hard to get around that. And in default, if somebody doesn't have documents or proper documents, and let's call the spouse isn't here anymore, the children will generally inherit equally. And we're going to focus a little bit more on this word equally. Now, the estate planning process can alter this default. Obviously, again, people are free to leave their assets how they want. And this is both during life and after death. Emotions run very high here. One has to be very, very careful. Leaving one child more than the other, certainly at death, can lead to families and children not talking to each other again, all sorts of fights. I often tell people that forget about the fact that the family gets along when mom and dad are living. That's why they're getting along. But if these items aren't dealt with properly after mom and dad are no longer here, that's when the gloves come off. And to me, it's almost rare when there's a family business or there's a lot of real estate involved that there's no fighting or little fighting. So one really has to think about this, plan ahead, and as they say, plan early and often. This is not easy, and work needs to be put into this. So let's look at what does it mean to inherit equally? Does an equal inheritance meaning giving everyone the exact same resources? Is it equity, distributing resources based on need, and then wouldn't be equal, it would just be on equity? What does each child need? Maybe one already has a lot of assets and one doesn't. Maybe one has 3 times the amount of children or grandchildren for the parent, or not for the parent, for the client. And then we get into fairness, impartial and just treatment without favoritism and discrimination. Should the child who took care of the parent during their old age and spent countless hours on their care and need, should that child get the same amount as another child? And or if there's a family business, how is that dealt with? Again, that's the big elephant in the room that really leads to a lot of problems if not dealt with properly. So benefits of equality, meaning leaving things exactly equal. Oftentimes, again, depending on if a child is doing more and may also be upset, but generally speaking, reduces family discord, avoids will or trust contests, helps the child's grieving process. If a child is not left equally, that child may have bad dreams and emotional and psychological damage the rest of the child's life. Heal old wounds without causing new ones, promotes family relationships. Because let's face it, if assets are left unequally, forgetting about how the child feels towards his parent, the child will be upset at his or her sibling as well and feel like, hey, the sibling influenced, did something wrong, was liked better. The first murder recorded in history was a brother killing a brother, known as a fratricide. Not a shock. There are jealousies, there are issues. So not only was the first murder that we know of a fratricide, it was, well, what I meant to say is not only was it a brother killing a brother, that's the first murder recorded, if we believe in the Bible. Oftentimes there are hidden inequalities. Tangible personal property. How's the jewelry left? Is it left only to daughters? Does the daughter-in-law get something? The granddaughter? And, there are oftentimes issues there. And, what do we do? And there are solutions, which we're going to get into. But, fights can occur over everything, even items that have sentimental value, even if they don't have a real value. Unequal control. Maybe assets are left similarly or equally, but who's the executor? Who's the trustee? Who's making the investment decisions? That leads to problems as well, or certainly could lead to problems. Per capita to grandchildren. Hey, I have more children than my siblings, if I did, or if I do. Should my children get more from their grandparents? And what's fair if there are more, and shouldn't all grandchildren get the same amount? And then illiquid assets. This again is the elephant in the room that we deal with all the time, and there's no perfect solution, but a lot of thought and care needs to be put into this. Control of the family business, and the real estate management. Now, real estate perhaps can be divided, but then who makes the management decisions? So if there are 3 children and they stay as co-owners, or their trusts stay as co-owners of the property, well, that's great. Maybe they're all getting distributions, but who's managing? Who's getting the management fees? Let's say one child wants out. Even real estate is very, very complex. And like I said earlier, for me, it's rare to see a family that owns a lot of real estate and there weren't problems in the end. Again, unless there's really, really terrific planning that's in place. And even if there's terrific planning, so much thought needs to be put into how that's done. We could have a whole hour or 2 program on at least my thoughts of how to avoid fights and disputes when it comes to real estate, which again needs to be put into place early, not when the parents are in their 80s and 90s. Family business, I mean, what do we do? One child's in the business, one child's not in the business. Does a child not in the business get a limited partnership interest? Does a child in the business get to make all the decisions and take whatever salary he or her wants? Is it possible to equalize where one child gets the business, another child gets life insurance? And that's really not equal either, because maybe the child has earned his or her receipt of that business, or maybe not, because that child got a benefit of being able to go into his or her parents' business, while the other child had to go to medical school or law school and also work their tail off. So, this stuff is complicated. And that's why I said, tax is easy. Tax, we could study and become experts and learn the rules and learn techniques. I think, any smart person can do that. But when we get into families and businesses and inheritances, Either we've got some background in psychology, or naturally maybe we have families and we've learned a lot over our lifetime, but it's really much more complicated. It's about wisdom more than I think studying, though, as I said earlier, more studying should be done here as well. So how do we build in flexibility? So, slats. That's all we're hearing about today. Spousal lifetime access trust. Dad creates a trust for mom and the kids. Mom creates a trust for dad and the kids. Let's take advantage of the estate exemptions. Great. But do we need to make a decision now as to when mom and dad are no longer living, how the assets pass? And the answer is no. And I tell people, let's get the documents done. We got tax legislation coming. We can still tinker around with that down the road. And one of the way we do this is through pot trust. A pot trust is a trust that basically is like a pot. You've got a pot of soup. No child or grandchild has any automatic right to get soup. It's up to the chef to distribute that soup. And if mom or dad is still alive, if one created the trust, the other one can still divvy up that pot of soup. After mom and dad are no longer living, typically in my planning, that pot gets divided. Nobody else should be able to alter what each child or grandchild gets. But there are times where mom and dad are uncertain how a child or children will turn out or behaving, and an independent trustee can oftentimes, with guidance, we'll talk about wish lists and other things, be able to still have some flexibility that it does need to go equal. And if we just read the slide quickly, pot trust allow spraying distributions, equal, unequal, based on need. Again, it all is depends on the drafting. I oftentimes also have a fit when people produce form documents without any thought. Yes, I mean, there are forms and there's a certain way of thinking, but none of this stuff is cookie cutter, especially because if we're dealing with a lot of assets or complicated families, and every family is complicated. I often quote Jerry Seinfeld at this point, who says that there's no such thing as fun for the whole family. No such thing, fun for the whole family. So at the amusement park, big sign, fun for the whole family. There's nothing that's fun for the whole family. So as you see, again, while mom and dad are there, one of them, let's say, could be the trustee deciding, but if they're not here anymore, consider an outside fiduciary, an independent person. Obviously, if a relative is deciding how much to give out, that's not going to be good. That's going to also create a lot of friction. Again, we've got to run through this quickly as I've got 13 minutes left, but pot trust is certainly one option. Disclaimer. I have never done this. I've done disclaimers, but not like this. So this is not my idea. I'm generally not recommending this, but it's out there. Leave the assets equally to the children. But if there's a wealthy child, give the wealthy child the flexibility where if the wealthy child filed a disclaimer in court, says, I don't want it, have the documents pass it to their sibling. So it's equal, and you're letting the child, the wealthy child, make the decision. I don't like it for a few reasons. Number one, who knows who's wealthy today and who's wealthy tomorrow? Number two, why should wealthy people get discriminated against? Just because one child becomes wealthy should get less from his or her parents? Not my view. Maybe it's the current view of this, the climate in this country, but not my view. I think there's still a notion of fairness, and people are people, and these are assets from the parents. But we can certainly have a lively discussion. And again, it may depend. How wealthy is one child? How not wealthy is the other child? The other issues, though, what if the child does it, that child's spouse may be pissed off. Hey, you gave up the inheritance from your parent. I know you wanted to benefit your sibling, but does that mean that you're going to write a check to your brother or sister for $1 million? And what are you doing behind my back? So there are spousal relationships in here too, and the children, the grandchildren, the children of the child could say, why are you giving away our inheritance? I mean, listen, I know your sibling needs, but I mean, this is from your parent. I mean, anyway, all sorts of complications, but disclaimers could be utilized where, again, it's passed equally, but you give the children the right. If they say no, instead of it passing to their children, meaning to the grandchildren, it goes maybe to a sibling. Powers of appointment, I've used these from time to time. Again, these are ways to adjust when assets are left in trust. Somebody can have the power to appoint it elsewhere, where even if it's supposed to go equal, there's power to rearrange. Flexibility is a key in drafting. Too much flexibility is no good. So it's always a fine line. I've used these where in the past where a child maybe didn't have a very good relationship with the parent, or no relationship at all. The parent wanted to disinherit the child. Generally, I feel don't disinherit children. It'll just lead to problems later. Again, there are certainly circumstances where, I can't tell a client what to do, and there may be good reasons, but a power of appointment is a way to add or subtract a child who may be in or out. Now, it gets a little wishy-washy giving somebody the power to add or subtract the child when the parent can't. Or when the parent can always tell this independent person what to do. But I've certainly seen court cases where this has been used. But bottom line is, it's certainly a tool. Again, assets can be put into trusts, planning can be done, and there are still ways to adjust it later. Of course, a will can be changed at any time. But while I say a will can be changed at any time, be careful of changing that will 10 times in the month before the client died, because that also leads to problems and contests and things of that nature. We'll skip this slide. This is, I think we see a Sigmund Freud there looking at the rationale for unequal treatment. This is important. Whatever you do, if you're going to treat your children unequally, don't put it in their face. Don't put it in the will. I'm leaving this child $5 million and this child $1 million. That leads to fight. That will literally be read over and over and over and over. It also may be a public document. So don't do that. You don't have to put it in your children's faces if you do decide to give one more than the other, which I'm not saying is a good idea to begin with. Again, though it depends on the facts and circumstances, but do it during life, right? What you do during life, it's better, it's quieter. Listen, your children don't have to know that you're helping one with tuition more than the other who doesn't need it. And again, I'm not giving advice whether to do it and what to do it. And there are obviously a lot of facts and circumstances, but I will say as a general point, don't put it in their face. Do it more in a quieter way and do it while you're living. Trusts and will substitute. Again, a will is a public document. A will gets filed in court. You could perhaps put aside money for one child or grandchildren in a trust. It's possible to keep that, I wouldn't say secret, but hidden or not in the face of the others. And of course, side letters, explaining to the children who got more, got less, hey, this is a reason why I did it. If you do think these things will be issues, at least explain it. Maybe explain it while you're alive. But you can also write a letter to your children. We're seeing more and more of that. Along with the will, I have a will vault at my firm. We have a vault of letters that people want me to deliver to their children or grandchildren. Nothing necessarily earth-shattering or revealing, but just, hey, don't fight with each other. We did the best we could. You may have certain issues and complaints about the way your parents have done things, but just know we love all of you. And here are some reasons. There are some who say, I have that big family meeting while you're alive and gather everyone in the room and have some drinks. And, I'm not a big believer in that big family meeting. I think people are only going to yell and scream at each other. And why should the parents have aggravation? Again, having that big family meeting to me is like, almost asking permission for parents to do certain things. And again, I'm not saying never have that big family meeting with everyone. That's not what I'm saying. There are certainly times that it's warranted, but be careful. You don't need to ask your children's permission. Getting their approval and understanding, absolutely. That's important if you can get it. And I think in many cases or most cases, if you do want to communicate what you're doing to your children, communicate with each of them separately. That big family meeting, I rarely see a point in that. Now, once everyone is on the same page, if you're telling your children, maybe there's business or real estate, you want them, you've got them bought in. Okay, once you've got everyone bought in, all right, then you want to have that big family meeting, no problem. And again, there's no hard or fast or clear rules here. It depends on the circumstances. I'm just referring to the notion that some people advise, oh, always have a big meeting, go through it with everyone. No, that's a recipe for disaster. It's like I'm taking my boys to a football game in a couple of weeks, and they all like a different football team. So one wants to see the Patriots, and one wants to see the Baltimore Ravens. One wants to see the Falcons. I don't know how I'm going to get to Atlanta. And then another would maybe see the Giants or Jets if they could. And if I would have spoken to each of them together, guys, which game are we going to? They would have, yelled at each other. And these are, young kids. Oh, I want to go to my game. Well, you went to Dad. You took us last time to his game. No, so I went to each one separately. I'm like, listen, guys, we're going to one game this season. We got to figure out the team. And separately, I got them each to buy in, and then I was able to put it all together. Call it diplomacy. And again, I'm not saying that's always the way to do it, but it's certainly something to keep in mind. But the bottom line is, as I speak quickly, thinking, there's nothing cookie cutter here. And I find, again, any attorney can draw up a good trust, not any attorney, but a competent attorney. Any attorney can do tax planning. Again, not any attorney, but one who's experienced with tax planning. You get to this other stuff, and don't get me wrong, I don't know that there is truly an expert, just like a psychologist or a life coach. Again, no one can know all the answers. No one can predict, but go to somebody who's at least wise with this stuff and can help, because families fighting over unequal inheritances or a division of real estate or the business, that will destroy the family and the assets much faster than any taxes. It's also interesting to me that when you get into the business and the real estate and those large assets, the corporate attorneys, they know the corporate documents, but they may not be the ones who really get the family dynamics. I think the trust and estates attorneys, or even a psychologist or some other professional, will be able to help with that more. So keep that in mind. I don't think there's enough knowledge and people out there who know how to deal with this stuff. We spoke about lifetime giving, a little less obvious. And again, I certainly encourage you to look at both the PowerPoint slides if you're able to print them, and also the article in Trust and Estates magazine of a similar topic. Side letters, again, they're being used more and more. Setting expectations. I was just speaking to a good friend of mine yesterday, and why do most people in life get upset? Whatever they get upset about. They're upset about a difficult marriage, a difficult child, not having enough money, stress, pressure, all about expectations, right? We get upset when our expectations aren't met. If we can, with our estate planning, at least meet or try to meet our children and grandchildren's expectations, that's going to help. How do we meet and set those expectations? Every case, it's going to be a little bit different, but we definitely need to do it. And again, if you take anything from this presentation, take estate planning if there are assets and children, which is in every case. There's nothing cookie cutter about this. You got to have thought about this. You got to have, besides, making sure that it's done in a way that's done with wisdom, with thought, with sensitivity, that you have proper documents and the communication to your loved ones is also there. Again, it may not be there while you're alive. It may be through a side letter after death. And again, build in flexibility in the documents that if you're moving assets into trusts while you're alive, you're doing, call it significant planning, make sure there's flexibility in there. Life changes, and just like I have $200 in my pocket, I can still decide how I'm going to spend that, whether I buy pizza for one child or take another child out to dinner. When I do estate planning and move assets into trusts, I should keep that same flexibility to the extent that I can. Again, family meetings, facilitators, private conversations, timing is everything. Again, timing is everything. You know, waiting to do this till you're in your 80s and 90s oftentimes is no good. Again, this stuff is so important. If you want your children and grandchildren to speak to each other, which is most parents' greatest wish, that their children and grandchildren always get along with each other. Bob Dylan, a quote from him that I found, there's no equality. The only thing people all have in common is that they're all going to die. How sobering. So I think my time is just about up. Thank you, Jonathan, for the tremendous opportunity once again.
Great. Thank you, Avi, so much. If anyone has any specific questions or new business opportunities or anything else that they'd like to discuss, feel free to reach out to Avi or myself where appropriate, and I'll be sure to include his contact information in the follow-up email to this program. There are a few people that ask about the handouts. I always include the handouts when people sign up in the automatic email. It's going to be included also in email tomorrow morning, along with the article that Avi referenced. So be on the lookout tomorrow morning. You'll get an email from me with that information. As I mentioned at the onset, the goal of these programs is to stay up to date on timely wealth management related topics and to collaborate where appropriate. And I think we can all agree that the clients who are best prepared are the ones who are served by a team of knowledgeable advisors. Two more quick items before I let you go. First, my next program will be on November 18th and is entitled The State-Based Right of Publicity, an Overview of Estate Tax and Valuation Issues, featuring Ladidis Lumpkins, partner in charge of private wealth services at New York-based accounting firm Prager Metis. Second, please take 30 seconds to fill out my survey at the end of this program. It helps me improve my webinars and provide timely and interesting content to attendees. And I thank you in advance for that. And with that, this concludes today's session. Please stay safe and healthy and have a wonderful day. Have a good day, everybody.